Okay. Hi, everybody. My name is Justin Morgan, and I would like to share with you some information about partnerships today. I'm a partner with the law firm Wood and Delgado. We are attorneys, advisors, and consultants. We work with dentists and private practice healthcare professionals throughout the United States. We're based in California and hold licenses in Colorado, California, and Texas. As a short disclaimer, the information that I'm going to be sharing today does not constitute legal advice and does not form the basis of an attorney-client relationship. It's supposed to be general advice only, and to the extent that you're about to enter into a transaction, I highly recommend that you obtain legal counsel to assist and walk you through the various issues, many of which we will talk about from a high level today. As my background, I went to University of California, Santa Barbara and graduated in 2007. I graduated from the University of Southern California in 2011. I externed for the Ninth Circuit and worked in commercial and bankruptcy litigation for about 5 years. Then I switched over and moved into private practice healthcare, first at Bank of America, learning how to finance acquisitions, startups, partnerships, and really understanding the financial components of small practices and large practices throughout the country. After about 1.5 years of that, I leveraged that experience into an M&A practice where I work with dentists and our basic client base on transitions, acquisitions, sales, startups, and everything in between. And so today, I really want to focus on partnerships and in group practices in which dentists and other professionals are grouping up to accomplish a similar purpose. Now, as a starting point, we start with the structure of ownership in general, right? And so there are business entities, which are legal fictions that exist only under the law, and they provide certain benefits to individuals in their operation of a practice. So at the baseline, there is no business entity. We usually call that sole proprietorship. All of these terms may differ variably and in minor ways, depending on which state in which you live. But you have sole proprietorship, which is operating by yourself under your own name. There's corporations and limited liability companies, which add a layer of legal protection between you as the individual and your business dealings. And so what that means is that you'll have a business entity that will operate your business for you, and that will transact with third parties, okay? And so if a patient comes in the door, they'll receive care from you as a provider, but they will be submitting their bills against the corporation itself. That corporation will also hire attorneys, they'll hire vendors, they will hire and order supplies, and they will hire and fire employees. And so if you have claims from an employee, it would be against the corporation rather than the individual itself. And that's important because it protects that individual from certain claims, and that can keep that person's individual assets safe, provided they comply with certain legal requirements that can be explained in detail by attorneys with respect to your particular situation. The two other instances, actually, two other types of entities are partnerships and limited partnerships, and those are going to be agreements to operate jointly between 2 or more people. In a general partnership, liability is going to be shared amongst the partners, whereas a limited partnership is slightly different structure, and you can have limited partners that have limited exposure, and then a general partner that has primary exposure. Now, when we talk about a partnership or a group practice, there are a couple of different ways they can group up. They can group up as individuals, they can group up as business entities, or they can group up as individuals and businesses. Typically, we recommend a tailored approach to our clients as to what structure they should choose, because there's benefits and risks to each, okay? So the benefit to forming a limited liability company or a partnership, say, of corporations, is that you limit your liability, right? As between general partners to a partnership, liability is going to be shared, but if those partnerships actually have S-corps as partners, or if the limited liability company has business entities as its members, And it's a distinction in legal terms only, and with respect to LLCs have members and partnerships have partners. And so when attorneys talk about it, they'll say a member is a member of an LLC and a partner is a partner of a partnership. But when you have this structure, and there's structures that can be put together, you can reduce the liability between the two partners themselves, right? So claims between the partners. So if there's a dispute and you want to sue your partner, or your partner wants to sue you, you want to limit your liability exposure. And you can also have limited liability from claims coming from outside of the partnership. And it's very nuanced and important to understand, because as we will see later on, there are legal documents that need to be drafted with an eye towards protecting the client from certain claims, and then also leaving the door open so that if there is a claim between the partners later on, you can go ahead and enforce it and have a chance of recovery. Now, and moving on to the second point here, there are benefits of having business entities as members of either the partnership or the limited liability company. And that's because you can achieve certain tax benefits by segregating those tax and expenses and allowing those to run through another business entity. And then also you can limit the liability between members or partners, as we previously discussed. And the third point is something I touched on previously, but it's important to understand that if you do structure it between two business entities, that you might need to address separately and understand what sorts of claims the individual owners of those business entities may have against each other. And I'll give you an example. So in one instance, there's two partners. They owned equal shares in a limited liability company. And one of them, after the partnership split up, wanted to sue the other one for alleged breaches of the contract. Now, the contract had been terminated for over 4 years, and the partners had kind of gone along on their way. And so you have two business entities, one of which is now defunct, the other one is carrying on this partnership. And there was some unclarity, there's going to be a dispute as to whether the individual that had sold his interest in the company was going to be personally responsible for the allegations of the other partner. Because if that person wasn't responsible, they'd really have no exposure, because that business entity that sold their interest has basically been deprived of any value. So it becomes very important to understand, when you structure these sorts of deals, how it's going to play out and whether there's going to be recovery if the partners do get into disputes. And that does happen from time to time. And I've seen some pretty recurring themes that we'll discuss today. Some of the benefits to grouping up with other people, you can allocate risk, right? So if two people owe $1 million of debt, that's better than one person owing $1 million of debt, right? You can reduce the overhead as a percentage of revenue by having two people working under the same roof. Now, dental practices, for the most part, there's two really big drivers that are variables. One is going to be the rent, and the other is going to be the employee cost. And so the more volume you can have using the same employees and the same space, the higher your profit margins are going to be. Additionally, partnerships allow two people to delegate responsibility, dividing up the tasks. If one partner is better at the administrative piece and the other partner is more interested in the clinical work, then they can both go off and pursue those interests separately and increase the revenues of the firm, and also reduce the amount of time that they need to spend on that practice. So there can really be some synergy there, where two people can actually be better or bigger than both of them separate, okay? In certain circumstances, and this is actually pretty nuanced, it can be easier to obtain financing for projects. So whether that project's an acquisition or whether it's a startup, it can be slightly easier if you've got two different balance sheets from working dentists to acquire a practice or start one up. Now, sometimes it can actually be a detriment, which we'll go into right now, which is if one partner starts to make different financial decisions that aren't cleared by the other partner, it can start to create problems. Certain of the risks are differences in, well, first of all, it's a lack of control over the entity itself. Now, if there are divergence on vision, strategy, and goals, partners can end up fraying at the ends, and they can lead to actually very difficult business splits, which we like to call really effectively a business divorce. And it's really painful, and it can be very stressful for folks if they go through that process, because it's going to be an unwinding of the assets. It's going to be an unwinding of the business that both of them created. One of the biggest risks that I see that usually is a driver in people splitting is compensation. And that the question that the partners need to ask is whether the pie is going to be big enough. So is there going to be enough dollars left over at the end of the day at year 1, year 2, year 5, year 10 to satisfy both the needs of the partners and their families and spouses? And it's unfortunate when it doesn't work out, or when folks haven't really thought this through, because the partners will know relatively quickly about the stresses that are going to be generated if they're not able to work full time and not generate as much money as they expected. Now, for example, I worked on a practice that was owned by 2 pediatric dentists, and it was a smaller practice. And had they worked with someone that really understood these points, they may not have done this deal, because the amount of revenue and the amount of work that was at the practice was really only sufficient for one person. And it was really it was more close to 75% of what one of those individuals could produce on their own. And so therefore they had 2 full-time jobs, and they're basically making 45% or 40% of their expected earnings, or the earnings they could realize had they been on their own. Second, there's financing risk, right? So when you go to a bank to ask for a loan, there's certain things the bank needs to see. Now, if you have 2 people on those loans, there are double the amount of potential pitfalls that the bank could basically disqualify a buyer or a financing opportunity on. And so it's important to understand the creditworthiness of your partner. And it's something to discuss in full and in detail with that partner before engaging in a partnership or considering buying into a group practice. Additionally, with partnership risk, there's reputational risk. So if one partner is acting a certain way that may look bad on the partnership, that could actually start to cause problems for the partnership. And there's also friendship risk, right? If you start working with someone and something else happens, right? If there's financial stress, or if there's compensation issues, or if one person's precluded of a business opportunity that they wanted to pursue, there can be a strain on the relationship between the 2 partners if it arose out of a partner or friendship, which is something that we often see. And then most of these partnerships should and are always governed by an agreement, right? And so a partnership can be formed with a handshake, but typically we're going to see a partnership agreement or an operating agreement for an LLC. And those agreements should be detailed, and they should be well thought out. And they're going to go through the bullet points here, which are who's going to control the business. Is it going to be 50-50 controlled? Is it going to be 41 or 49-51 controlled by one partner? Or is one partner will one partner have effectively no control? Second is ownership interest, and these 2 can differ. You can have someone in control of the practice in terms of all major decisions, but they may own a smaller interest percent than the other partners. Control and management are very similar, but sometimes you have a manager that will come in and will manage a limited liability company or a partnership that has authority to make decisions that the other partners do not. And then there's questions of how do you remove that person? If they can be removed, how much are they going to be paid, and what are their responsibilities going to be? Dispute resolution is a major issue. It's the avenue by which the parties are going to resolve any disputes that may arise. And so under what circumstances will the partners get a formal legal process involved? Under what circumstances will they defer to maybe an independent business advisor for a decision, and that's the process that needs to be understood by the parties, so that it becomes easier to resolve those disputes. Another major term that needs to be discussed is what happens if one partner needs to buy the other partner out. And so this is what we have occurring in 50-50 partnerships, where you have two partners that equally own the same amount. And sometimes when we see partnerships not drafted with a full understanding of how these things play out, it won't be addressed how one partner can force the other partner out. And there's a bunch of different clauses and there's a bunch of different approaches, but one would be, in the event of a dispute, we will both submit offers to the other person, and the person with the higher offer has to accept it and then buy the other person out. And that effectively creates this double blind offering system by which it tries to get to a really fair value rather than having someone under ask or over ask. Okay. Distributions are something that needs to be addressed. How often are they going to be? How much cash is going to be left in the bank account for the practice? It's really important because you can have two different people that have wildly different expectations in terms of how much cash they want in the bank account. Some people that are conservative might want 6 months of expenses in reserve, but someone that might be more aggressive might say, I want 2 months of expenses and reserves. I know that I'm going to be working, I have insurance, and I want to be able to use that money for my own investing activities, for my family, and just to be able to have that rather than it being sitting idle in a bank account. Additionally, what happens if the one partner wants to sell their interest in the company or sell the company, right? What if they want to sell it to another group practice to try and join into the DSO train? Or what if the partner wants to buy the other one out, but the remaining partner doesn't want to sell? These are issues that come up all the time. And without a good legal document providing what happens in certain circumstances, it can be really difficult. And one example is I'm working on a sale as we speak, in which my client wanted to buy her partner out because they had retired, but that partner wants to hold on to the practice and keep it in the family and not pay taxes on the sale. So he refused to actually sell his interest. And so it took some time for those two to figure out and negotiate who gets to buy who out. And without detailed language, it becomes a more difficult conversation and a negotiation between the parties. Additionally, other matters should be, how do we admit new members and under what circumstances, and who has the authority to admit new members? And then finally, what actions can each partner take without partnership approval? Can a partner go buy a new fax machine or a new copying machine without having to go to a formal partner meeting? Or what sorts of things can they go ahead and do on their own, and allowing them to move faster and making decisions from a business standpoint without the approval of everybody else? It's important to have these things and others detailed in the applicable contracts so that everybody's on the same page, and it prevents and takes away some of the risk of disputes later on. Other considerations are intangible things like personalities, right? When we talk about great partnerships that work out well, are they two personalities that clash, conflict, or really work together to bring more energy and growth to the company? A good balance might be someone's very interested in business development, growth, and marketing, while the other partner might be more of a clinician. Additionally, ambitions are really important. If one person wants to work 3 days a week and the other person's willing to work 6, it can be a source of tension if they're not both on the same page with their work ethic, and maybe not work ethic, right? But the amount of time they want to spend on that business. And long-term planning factors into that as well. Whether someone wants to own 1 practice or they want to own 4 practices or 40, those all are really important for the partners to understand on the front end so that they avoid issues later on. Even if you have a great friend and they've been a great friend for a long time, that doesn't mean that they're a great partner for you simply because of some of these issues, right? Family plans play a role in this, and then also risk tolerance. Risk tolerance is huge to really understand because it ties back into this conservative versus risk, favoring risk sort of approach, because someone that likes risk may say, hey, let's open up 2 practices a year for the next 5 years. And someone who doesn't like risk may say, I'd like to open up one practice every 3 years. And that can make both of them feel really uncomfortable because they both be pressing in different directions. And so it's good to have those conversations up front. Again, I spoke about the 2 pediatricians in a small practice. It really doesn't work, and it's something that I talk to my clients about all the time, which is make sure that there's enough revenue for both parties. There's another instance where I had 2 GPs in a growing practice, right? One GP was nervous to do the practice by themselves, okay? And so he enlisted the support of a friend who already had a practice, and she said, I will go ahead and use my business acumen, my finances, and my staff to help grow this practice for you. Now, while there was a bunch of benefit in growing the second practice, it grew very, very quickly. The first owner was working the entire time, and the second owner realized that person, they didn't need either person at the end of, let's say year 1. The person that had the business acumen and the staff felt that they could probably replace the other partner at a lower cost. And the other partner didn't really need the staff and the business acumen of his partner anymore because she was never actually at the practice and he was doing the growth. He was bringing in referral sources and actually doing the heavy business development in addition to the clinical work. So it's important to understand the nuances and how all of it's going to work out over a long period of time and not just be based off of friendship. And, we see this working for a few years without really digging into how it should work out, in a couple of different circumstances. Another circumstance in which there was a fair amount of tension was it was a GP and an RDH, and they formed a practice together. I think the RDH had already been in the practice and the GP was there every once in a while, so they knew the practice a little bit, but it was difficult for them to get on the same page because they had very different skill sets and expectations. Whereas the RDH expected maybe to work full-time as an RDH and didn't expect to have to do any active management of practice, that's what the dentist expected from the RDH. So the RDH was not able to help her with some of the tasks and functions that she wanted assistance with, and it caused a lot of tension between the 2 parties. So the thing to take away is that partnerships, and even when you get to 3 and 4 or 5 people, are really complicated. And it's as much from a legal construct as from an interpersonal dynamic construct. And it's important to understand the motivations of each party and where the pitfalls are so you can make a really good decision. For dental practices and for smaller businesses, I typically like the idea of retaining as much control with my client as possible and only partnering if it's an opportunity that otherwise would not be available. And so there's opportunities that will arise in acquisitions and opportunities that will arise with startups in certain areas that can't be achieved by a single practitioner, right? So if you have 2 doctors coming in to buy a $3.5 million practice and they're competing with a DSO or a large group practice, it makes sense to group. It makes sense to combine finances to get that practice and be able to compete so that you can get a step into that larger market. Additionally, if you're starting let's say a multi-specialty practice in an expensive area with high rents, it can also make a lot of sense to have another partner that you're working with help secure that space and reduce the lease risk. Because we're seeing, $9,000, $10,000 a month in rent, and it's really hard to make that work in terms of the bank's traditional financing approach. And so it's important to understand that there can be opportunities if you have a good partner, but it is also really sensitive because there needs to be sufficient growth for both partners to meet and exceed their expectations financially. At this point, I know we have a few people in the room. If there are any questions or if there are any additional stories that the Jorgensens may have, I would love to hear them, and we'd love to be able to share those with folks as they listen to this on recording.
Oh, I mean, the stories out there, as you can imagine, for every single partnership that comes up, there are stories about what worked and what didn't work about it. So, again, we'd be happy to answer any questions as well. But thank you for sharing that. Very concise, very organized. It all comes down to if you plan for it, you can have a great outcome, and if you just kind of wing it, then it is not a good approach to things.
Yeah. Well, I don't see any questions in the chat, so I'm going to go ahead and stop the recording and thank you for listening. If you have any questions, my contact information is below. It's Justin@dentalattorneys.com, and that's my cell. And so you can reach out. Email is the preferred route. And I hope you all are well. Thanks so much.